Right, back live with you tonight, John in Focus. Let's take you back to this story now. Mzwanele Manyu, who speaks for the Jacob Zuma Foundation, says lawyers for the former president are likely to appeal a judgment handed down earlier today by the Johannesburg High Court. The lawyers are convinced that a higher court may rule in their favor in the private prosecution matter. For more on this, we're joined now by Benedict Phiri, who's going to help us get some understanding of what the courts are saying. So before we get to the prospects of maybe a higher court finding this matter differently, by the way, good evening. Thank you for coming in.
It's a pleasure, Thabo.
Let's first look at what the courts are saying and what they've had to look at. I mean, it's the same matter, I suppose, that Karen Mon and Advocate Billy Dana were dealing with. To an extent, quite different because the president is being privately prosecuted of being an accessory after the fact. But much of the question was around whether or not that certificate includes President Cyril Ramaphosa. What did the courts find?
Yeah, and I think that's the major difference between the Billy Downer and Karen Mon matter, because obviously with respect to Billy Downer, that nolle prosecute named him specifically. Right. With respect to the president, there was no mention of the president. That's what the court has found now, not only in the nolle prosecute certificate, but also in the complaint by Mr. Zuma to the police, the SAPS. The court found that he wasn't even mentioned in the context of being an accused, and there's no ways that the DPP could have applied herself to whether he was an accused. So on that basis, the nolle prosecute certificates did not mention the president, and therefore it wasn't a nolle prosecute certificate that would give rise to a private prosecution. And as you know, that's a fundamental jurisdictional fact that a private prosecutor has to establish before bringing a private prosecution. They have to have a nolle prosecute certificate, and then they have to tender security to the court, and then they can get the summons. But in Mr. Zuma's case, he didn't have the nolle prosecute certificate, and he didn't tender security for the president's costs. So on that basis alone, he couldn't get out of the starting blocks and bring this private prosecution.
But nobody is talking about the fact that how did these people get hold of a blank nolle prosecute certificate that they think they can use and add names as they like?
Yeah, and I think that was a major set of events that the courts the court looked at insofar as the second piece of the matter, because the matter basically hinged on two pillars. There was the first pillar, which related to the validity of the nolle prosecute certificate, and then the second pillar related to the unlawful motive, rather, if we can call it that, behind the private prosecution. And when the court looked at the sequence of events and the narrative, it said, well, you only wrote to the DPP at a particular point in time, and it was after you'd already made the complaint to the president. So at that point in time, the president was never contemplated as a suspect, right? So the fact that you pushed the DPP to come back to you to say it doesn't apply to anybody, after you'd first said, where's Karen Mon on this nolle prosecute certificate? And then afterwards, the DPP said it doesn't apply to anybody. And it's on that basis that Mr. Zuma then decided to then launch the private prosecution against the president. But what's even more curious is that there was a period of time that had even elapsed. And actually, what the court found as weighing in favor of the finding that the prosecution was for an improper motive or an improper purpose was it was brought on the eve of the ANC elective conference after a period of 16 months. So the court found, in fact, it said that Mr. Zuma's explanations were unsustainable in that particular respect.
So the argument was, I mean, even at the time, was to say, well, President Cyril Ramaphosa, he can challenge the nolle prosecute certificate if he wants to, but he must first go and appear in court in the matter, the private prosecution, and then appear there, and then he'll challenge it afterwards. And they are seeing this as a way of blocking prosecution. Does this set precedents to say somebody can decide to block prosecution for whatever reason, and if they feel they want to challenge the nolle prosecute certificate?
In a way, it doesn't set precedent because, the court judgment delved into a long list of court authorities, where the courts had held that there are two ways that you can challenge the title of a prosecutor. We obviously know of the Section 1061H because Mr. Zuma brought that in his corruption trial. But where a criminal prosecution is started on an unlawful basis, it's open to anybody who's the subject of that prosecution to stop that in a civil court. So the court said, yes, ideally we do not want to have a situation where everybody runs to a civil court to stop a criminal prosecution. So it must be that there are really good reasons, including that the process itself is legally defective and threatens fundamental rights in the case of the president in this particular instance. So the court found that where there's those factors present, then it's open to a person who's subject to a private prosecution to approach a civil court even before the criminal matter has started to have that civil court halted. And the court found this has been the position in our law for as long as I think the 1950s. And there's been a number of successive cases, including all the way up to the Constitutional Court, that have actually dealt with this principle.
Now, what's the status of this nolle prosequi certificate at this particular point? Because, I mean, should, again, the Jacob Zuma Foundation saying we are appealing this, is that nolle prosequi still active? Are they still going to use that to say, well, we still have this, so President Cyril Ramaphosa must still come and appear?
So, as it stands, there's no nolle prosequi certificate. There's no private prosecution against the president. And I think even what was a little bit more surprising is that Mr. Zuma cannot bring any further private prosecution against the president on the same facts or for the same charge. I think the court there went a little bit further than we had anticipated. So it's, unless there's a successful appeal, this matter is dead. It won't go any further.
Yeah, let's talk about that appeal. I mean, what would be the grounds to bring an appeal on this matter?
I honestly do not see the grounds because, I think it's very clear that that nolle prosequi certificate did not apply to the president. Not only did the court interpret it in that way, but we had the benefit of the affidavit of the DPP that said that, when I was considering everything, I never considered this, right? So I think it's very clear that an appeal court would find the same on that particular aspect. Secondly, there was no security tendered. And if there's no security tendered, you can't bring a private prosecution. The fact that the security was tendered after the summons was issued, the court found was not condoned, and that's not something that should be condoned in this particular context. So on those two aspects, I think any prospects of success on appeal are very slim for the former president, and I don't think it would be well advised to try and take this matter on appeal.
Yeah. You say it does mention Advocate Billy Downer. It doesn't mention Karen Moon. What does this mean for the status of that particular matter?
Well, this particular matter with the president has very minimal impact on the matter relating to Karen Moon and Billy Downer. Yes, the two interplay, and there are certain legal principles that operate the same, insofar as at least the matter around improper motive. I'm just using that term loosely. But the two matters don't really have an impact on each other. So I guess what the president might want to focus on, if he wants to stay out of his corruption trial, is probably appealing the Billy Downer and Karen Moon private prosecution outcome, because then that at least keeps Billy Downer at a point where he could potentially bring an application for him to be removed from the trial. But insofar as the president is concerned, it doesn't actually impact that corruption trial. And what the court said today was this was actually intended for the ANC elective conference. And I guess the question is it actually intended for anything else? And, if it's not, then I don't see why the president would want to appeal this.
But interesting that you bring that. How was that particular matter of Billy Downer and Karen Moon processed in the Armsdale trial? Is that process being kept in abeyance, awaiting the outcome of this process on the private prosecution?
So Mr. Zuma had said in that trial that he would bring an application to remove Billy Downer on the back of this private prosecution that he was bringing. So the trial has not returned to court since the outcome of the Billy Downer private prosecution. I think we all wait with bated breath to see what his next move will be. As far as I understand or know, there hasn't been an appeal noted in that particular matter. And so we'll wait and see what happens in the criminal trial. I wouldn't be surprised if we see an appeal on the eve of that matter sitting again, simply because it would give Mr. Zuma's counsel an ability to say, we have an appeal in the other process. Can we request that this matter be postponed until that appeal is ventilated? But certainly the NPA will oppose that strenuously, I'm pretty sure.
Yeah. We've highlighted, at least in our reporting, the cost order as well. Is it significant that the courts decided to grant at least President Cyril Ramaphosa that cost order?
It's not significant. In law, typically if you win a matter, the other party has to pay your costs. There are some exceptions to that rule. For instance, if it's constitutional litigation, we heard even in that court talking about the BioWatch principle, etc. So it's not significant. That's what would have happened in any event. I think what the President's Counsel abandoned during argument was an order for punitive costs against both Mr. Zuma and his legal representatives during the hearing. So that the court didn't have to decide that because it was abandoned. And I think that would have been significant if something like that had been ordered. But the cost order that was given is typical of a matter of this nature and the outcome.
What are the legal principles here that we are coming up with?
So I think what is exciting is the fact that we've clarified the manner in which the baton from the NPA gets handed on to a private prosecutor. I think it's important to set the parameters within which that should happen, right? And I think the law has benefited tremendously because, let's face it, the NPA is struggling. I don't think anyone can argue with that, and there are private prosecuting bodies that are looking to take over that mantle where the NPA is unable to do it. And I think a decision of this nature is very useful and helpful to that process overall.
Benedict, appreciate your time.
It's a pleasure.
Much for coming in. That's Benedict Phiri. They're giving us some analysis of the outcomes of the Johannesburg High Court. And most importantly, where to from this point.